But we begin with day 3 of the January 6th committee hearings. Today, a panel focused on then-President Trump's pressure campaign against former Vice President Mike Pence to overturn the 2020 presidential election. We heard testimony from those close to Mr. Pence about former President Trump's efforts to reject electoral votes in an unprecedented manner. The committee heard from the Vice President's counsel, Greg Jacobs, and retired federal judge Michael Ludig, who advised the VP in the aftermath of the election. Both were against the plan conceived by conservative lawyer John Eastman, working on then-President Trump's behalf, for Mr. Pence to reject the electoral count on January 6th, a plan that was embraced by Mr. Trump himself in the lead-up to the Capitol riot. The hearing was direct from the start.
What the president wanted the vice president to do was not just wrong. It was illegal and unconstitutional. We will hear many details in today's hearing, but please consider these 2 points. First, President Trump was told repeatedly that Mike Pence lacked the constitutional and legal authority to do what President Trump was demanding he do.
Was it your impression that the vice president had directly conveyed his position on these issues to the president, not just to the world through a dear colleague letter, but directly to President Trump?
Many times.
And had been consistent in conveying his position to the president?
Very consistent.
That declaration of Donald Trump as the next president would have plunged America into what I believe would have been tantamount to a revolution within a constitutional crisis.
Our review of text, history, and frankly just common sense all confirmed the vice president's first instinct on that point. There is no justifiable basis to conclude that the vice president has that kind of authority.
And Chief Washington correspondent Major Garrett joins us now. Hey, Major. So some really striking testimony from some very conservative lawyers. What was interesting was the lawyer for former Vice President Mike Pence said that when Pence heard about the scheme to overturn the election, he rejected it. Here's attorney Greg Jacobs.
The vice president's first instinct when he heard this theory was that there was no way that our framers, who abhorred concentrated power, who had broken away from the tyranny of George III, would ever have put one person, particularly not a person who had a direct interest in the outcome because they were on the ticket for the election, in a role to have decisive impact on the outcome of the election.
So you have Vice President Mike Pence rejecting that proposal, but what else did we learn about John Eastman's roadmap to try to keep President Trump in office?
Well, first of all, that it was a roadmap of an invention. It's not part of any scholarship associated with what the Constitution says, what the 12th Amendment says, what the Electoral Count Act said. It essentially is made up out of whole cloth. That's the most important thing that emerged from today's testimony and other reporting leading up to today. This is not a theory that has any traction, Caitlin, anywhere, but it had traction in the Trump White House in the waning days of the Trump administration for one reason and one reason only. Former President Trump wanted to believe it and see if he could put it in motion. And the central roadblock to putting this cockamamie constitutional theory, and I'm being generous with those words, was the Vice President, Mike Pence. And privately and publicly, the former president tried to use his Twitter account and rhetoric and face-to-face meetings, not just with the former vice president, but with his staff, to pressure them to do something they knew was illegal, unconstitutional, and utterly without precedent in the history of our country. And all of those things emerged very clearly today. And the voices, Caitlin, that articulated those central facts were not constitutional alarmists, people who use florid rhetoric to talk about dangers to our constitutional republic and the democracy that supports it. These are people who are very constrained in their rhetoric and language, Greg Jacob and Michael Ludig. But they both used rhetoric that was basically saying this presidency, in its waning days, was trying to set fire to the Constitution, overturn a valid and confirmed presidential election, and topple everything that this country had previously understood about the rule of law. That's pretty striking.
Absolutely, and that's a really important point to underscore, that these are conservative attorneys. And hearing from Ludig in particular, you could just hear and kind of feel the weight of this moment. I mean, he really took his time with his words, made his argument very clearly, and you could tell that he was doing this out of a sense of duty, really, to the Constitution and to the country. What's also interesting, and Major, I know you have reported extensively on Trump and Pence throughout the campaign, throughout the presidency, and what was striking here, too, is that we saw kind of the fraying of the relationship between Pence and Trump. Pete Aguilar, one of the congressmen on the committee, brought up our own Robert Costa's reporting from his book, which kind of described this rift between Mike Pence and Trump leading up to January 6th. I think we have some of that.
In the book Peril, journalists Bob Woodward and Robert Costa write that the president said, quote, "If these people say you have the power, wouldn't you want to?" The vice president says, quote, "I wouldn't want any one person to have that authority." The president responds, "But wouldn't it almost be cool to have that power?" The vice president is reported to have said, "No, look, I've read this, and I don't see a way to do it. We've exhausted every option. I've done everything I could, and then some, to find a way around this. It's simply not possible."
So what do we know about how frayed that relationship was?
It became very frayed in that moment. And I think it's worth pointing out a couple of things that we heard from that excellent reporting of Bob Woodward and our colleague Bob Costa. The vice president didn't say to former President Trump, "Look, you're wrong from the outset. I'm not even going to look into this." He could have said that and been on completely firm legal, constitutional, and historical ground, but he didn't. He said, "I've looked into this, and then some." Caitlin, this was true of so many people who worked in the Trump White House. It wasn't that they told the president, "I'm not going to listen to you. I'm going to disregard your theories about the election. I'm going to look into them." And once they did and looked into all various corridors of it, whether the election was stolen, whether there were irregularities, whether there were votes that were switched, all these various theories, they looked into all of them, found no justifiable basis for any of them. And then the vice president looked into this particular very unusual, and again, I'm being kind, constitutional theory, and said, "It's not there, Mr. President." So they were trying to be loyal to their jobs, to the person who employed them, the President of the United States, but more importantly, the institution and the Constitution they swore an oath to. And ultimately, it was that loyalty that, if you'll allow me, I rarely do this, trumped the request of the president.
Yeah, it's a fair assessment to use there, and a good reminder, too, that Pence was the most loyal in the Trump administration and his ally. And another really striking moment came, in my view, from White House lawyer Eric Hirschman. He was discussing Eastman's plan to reject the electoral votes. Listen to this.
He described for me what he thought the ambiguity was in the statute, and he was walking through it at that time. And I said, "Hold on a second, I want to understand what you're saying. You're saying that you believe the vice president, acting as president of the Senate, can be the sole decision maker as to, under your theory, who becomes the next president of the United States?" And he said, "Yes." And I said, "Are you out of your effing mind?"
So we heard from others today, too, that Eastman himself admitted that this plan wouldn't even hold up scrutiny in the Supreme Court. Jacob said as much, that it would likely not stand, the Supreme Court wouldn't stand for it. So what does the committee seem to be getting at by pointing all of this out here?
That John Eastman knew that this was a theory that had no constitutional or legal foundation beneath it, and that he was selling it to former President Trump in order to curry favor for unknown reasons. And in so doing, he was part of an effort to subvert the will of the people, to interfere with a congressional process to certify a presidential election, And that is why the committee disclosed today he took the Fifth Amendment 100 times during his appearance before the committee, and as the committee disclosed today, asked to be put on the pardon list. So the audience, I invite you to consider, why does someone take the Fifth Amendment? It is that person's constitutional right, of course, 100 times, and then try to get on the pardon list if they believe this theory is valid, legal, and consistent with the Constitution.
Also, as today's hearings were getting going, we learned that the Select Committee wants to and will ask Ginny Thomas, who of course is the wife of Supreme Court Justice Clarence Thomas, to come in for an interview. Can you kind of remind us about why they are interested in her and kind of the conversation she was apparently having with the president's chief of staff?
Right. So Bob Costa, our colleague, has reported, along with Bob Woodward, that there were text messages between Ginny Thomas and Mark Meadows, urging him to stand tall and do everything he can to stop the certification of the Biden election and to retain former President Trump in power while he was still in power. Then we've also learned there were some kind of email conversations between Ginny Thomas and John Eastman. And one of the things we learned today in the testimony from Greg Jacob was one theory that John Eastman had is if this was ever challenged in court and brought before the Supreme Court might not want to wade into this because it's a political controversy that the Supreme Court might decide was out of its realm. Now, you have to go back to Bush v. Gore and remind yourself the Supreme Court has waded into political controversies before, so it's not really logical that it wouldn't have this time. But anyway, that was John Eastman's theory. Was that in any way informed by conversations with Ginny Thomas, the wife of a sitting Supreme Court justice? The committee wants to find out about that and just how much Ginny Thomas's advocacy on this front, again, to keep President Trump in power and to deny the valid and verified election results of 2020, how much of that bled over to any of her conversations or likely outcomes that would have been brought to bear by a sitting Supreme Court Justice, Clarence Thomas.
Very interesting questions and some consequential action that could come from the revelation of those text messages. Major Garrett, as we are every day, but especially on days like today, we are grateful for your insight and reporting. Thank you.
Thanks.